of High Courts in India, 25 HCs at present. Appointment of Chief Justice. Article 217. In consultation with CJI and Governor of the State. Appointment of other judges. As per SC's guidelines in third judge's case. News summary. Background. The institution of High Court originated in India in 1862 when the High Courts were set up at Calcutta, Bombay and Madras through the Indian High Court Act, 1861. Although the Constitution of Independent India provided for a High Court in each state, the 7th Constitutional Amendment Act, 1956 authorized the Parliament to establish a common High Court for 2 or more states or for 2 or more states and a union territory. At present, there are 25 High Courts in the country. Appointment of judges of a High Court. Appointment of Chief Justice. Under Article 217 of the Constitution, the judges of a High Court are appointed by the President. The Chief Justice of a High Court is appointed by the President after consultation with the Chief Justice of India and Governor of the concerned state. Appointment process of other judges, as per the guidelines of the Supreme Court in the third judge's case, 1998. Following procedure is followed while appointing judge of a High Court. The proposal for appointment of a judge of a High Court shall be initiated by the Chief Justice of the concerned High Court. The High Court Collegium, which comprises the Chief Justice of the High Court and 2 senior-most judges, recommends a name for a High Court judgeship to the Supreme Court Collegium. The Supreme Court Collegium, which comprises the Chief Justice of India and 2 senior-most judges, then considers this recommendation. The SE Collegium can either approve the recommendation and then transmit the same to the Union Ministry of Law and Justice for giving effect to it, or it can disagree with the High Court Collegium or defer the proposal. The role of executive. If the Union Ministry of Law and Justice has any reservation on the grounds of suitability or in public interest, it can send back the recommendations to the SE Collegium with specific reasons for reservation recorded. If the SE Collegium after reconsideration still reiterates the recommendations unanimously, such appointment should be processed. The Union Ministry of Law and Justice then submits the recommended name, S, for appointment to High Court judgeship, to the President of India. Eligibility. There are 2 qualifications required for a person to be appointed as a judge of a High Court. He/she should be a citizen of India. He/she should have held judicial office in the territory of India for 10 years or he/she should have been an advocate of a High Court for 10 years. The Constitution has not prescribed minimum age for appointment as a judge of a High Court. News summary. The Supreme Court Collegium, headed by the Chief Justice of India N.V. Ramana, picked 68 names from a list of 112 probables. In April 2021, the Supreme Court had underlined concerns about vacancies in high courts. As per the Ministry of